A super quick update here in the never-ending Fat Joe case back and forth saga with Tyrone Blackburn, Terrance Dixon, Joe Tacopina. There's just so much going on. If you need to catch up, there is a playlist linked in the description. But today, what I saw hit the docket was a response from, it's written by Joseph Tacopina for Fat Joe, but we also have the Peter Torres, Richard Jaspitra, and Eric Moreira parties joining in this response. So this is a response to Tyrone Blackburn's motion to withdraw as counsel for Terrance Dixon. We looked at that on a previous stream, so go check that out. And here they're not opposing the withdrawal, but they're writing to clarify some other issues, namely that, hey, when you hear this motion to withdraw, you should make it clear to Tyrone Blackburn that that will not remove him from your court's jurisdiction. You'd still have jurisdiction over him for the remaining issues that need settling, like motions for Rule 11 sanctions. So here we go. Let's read this. It says, Your Honor, Joseph Cartagena, Sneaker Addict Touring LLC, and Slate Inc., collectively Mr. Cartagena, respectfully submits this response pursuant to the court's July 9th scheduling order to the motion of Attorney Tyrone Blackburn and T.A. Blackburn Law, his law firm, to withdraw as counsel as record for Terrance Dixon in Cartagena v. Dixon and Dixon v. Cartagena. Although Mr. Cartagena does not oppose Mr. Blackburn's withdrawal as counsel for Mr. Dixon, he respectfully submits his response to clarify the limited basis for his non-opposition, to dispute certain unnecessary factual assertions contained in Mr. Blackburn's declaration, and to make clear that Mr. Blackburn's withdrawal has no effect on this court's continuing jurisdiction over him personally, with respect to any pending motions for sanctions and contempt, or any future motions seeking such relief. And then this is where they note that the other parties are joining in. Mr. Blackburn asserts two grounds in support of his motion to withdraw. First, he contends that he's simultaneously a witness and an attorney in these proceedings, such that his credibility will necessarily be at issue before the jury, and that, with regard to him, quote, a fact finder cannot reliably assess the credibility of an attorney who appears both as an advocate and as a potential witness on the contested facts. Second, he asserts that he harbors such genuine and irreconcilable personal animosity towards Mr. Cartagena and his counsel that his continued representation would guarantee a degraded representation for Mr. Dixon. Although the truth or falsity of the allegations involving the service of process on Mr. Blackburn, that's the whole thing with the process server, does not form the basis of the defamation claims at issue in this case, they are relevant to Mr. Blackburn's credibility. Moreover, Mr. Cartagena has no basis to dispute Mr. Blackburn's assertion that he harbors genuine personal animosity towards Mr. Cartagena and his counsel. Accordingly, Mr. Cartagena does not oppose Mr. Blackburn's withdrawal as counsel for Mr. Dixon. That said, Mr. Dixon vigorously disputes the overwhelming majority of the factual assertions contained in Mr. Blackburn's declaration submitted with his motion. Those allegations are largely extraneous to the legal issues presented by the motion, and notably, are not cited in Mr. Blackburn's memorandum of law. But because the two grounds identified in Mr. Blackburn's memorandum are independently sufficient to support withdrawal, there's no need for the court to resolve or even consider the declaration's remaining factual allegations in deciding this motion. With respect to the first ground, Mr. Blackburn references his grand jury testimony, that's over in the criminal case, and notes that the grand jury returned a no true bill. That means they decided not to indict, concerning the allegation that he committed a vehicular assault while service of process was being effectuated. And we've got a footnote. The footnote reads that fact does not alter Mr. Cartagena's position, as he maintains that the vehicular assault occurred. Moreover, the grand jury's decision has no bearing on the issues presented here, because Mr. Cartagena was not a party to that proceeding. Consequently, neither res judicata nor collateral estoppel applies. And back up to the text. Critically, however, Mr. Blackburn's credibility will be a central issue before the jury, for reasons extending well beyond his grand jury testimony. Mr. Blackburn also testified as a defendant under oath at a deposition in these proceedings, and Mr. Cartagena intends to demonstrate at trial that portions of the testimony were false, misleading, evasive, or otherwise lacked credibility. Among other things, Mr. Blackburn claimed that he could not recall representing his own client, Terrance Dixon.
So many cases, I don't know. It's like a lot of cases.
At a deposition conducted only shortly beforehand, repeatedly professed not to remember material events, attributed his inability to recall to the effects of his medication, and answered, I don't recall, to numerous significant questions. And we've got a footnote there that does the counting. They say, see the June 23rd, 2026 order. That's the court's order. Where in the order, it says, Dixon stated, I don't recall, at least 46 times during the deposition. These credibility issues, back up to the text here, these credibility issues formed part of the basis for the court's order sanctioning Mr. Blackburn and will plainly be fertile grounds for cross-examination before the jury. They cite again to the June 23rd order. At the March 6th deposition, Blackburn was initially unable to confirm whether he represented Dixon. He was unable to confirm whether he was present for the Dixon deposition just 2 weeks prior. He was unable to answer basic questions of him. After plaintiff called the court, Blackburn was suddenly able to affirm that he represented Dixon, but was unable to recall that he could not definitively state that Dixon was his client minutes earlier. As discussed supra, the record is devoid of corroborating evidence that Blackburn was still on medication on March 6th. Assuming arguendo he was on medication, there is no evidence in the record that that medication would have caused the selective amnesia that was on display at the March 6th deposition. That was all quoted from the order there. And shout out to /star who pulled some statements that Blackburn gave to law.com. And down here at the bottom, one of them says that Blackburn said he plans to present to the grievance committee his medical records to account for his behavior, and also that he plans to appeal Willis's sanctions. Continuing with this letter, notably, Mr. Blackburn's credibility will be directly at issue because Mr. Cartagena alleges that Mr. Blackburn himself actively participated in the extortionate scheme giving rise to this litigation. And then they cite the second amended complaint from Fat Joe, and quote, frustrated by his inability to overcome Cartagena's resolve, Dixon upped the ante by hiring Blackburn and Blackburn Law to shake Cartagena down. But Blackburn is no ordinary lawyer. He's an extortionist masquerading as a lawyer in a cynical ruse to use the court system as both a sword and a shield for his unethical conduct. And that's the end of the quote. These allegations place Mr. Blackburn's own conduct squarely before the jury and make him not merely a peripheral witness, but a principal factual participant whose testimony, motives, and credibility will be necessarily scrutinized. Under these circumstances, Mr. Cartagena does not dispute that Mr. Blackburn should not realistically serve as both trial advocate and witness. The same is true of Mr. Blackburn's second asserted ground. Mr. Blackburn represents that he harbors such genuine and reconcilable personal animosity that continued representation would guarantee a degraded representation for Mr. Dixon. Mr. Cartagena has no basis to dispute Mr. Blackburn's professed state of mind. Indeed, because Mr. Blackburn's own conduct will itself be the subject of testimony and vigorous cross-examination at trial. Indeed, because Mr. Blackburn's own conduct will itself be the subject of testimony and vigorous cross-examination at trial, and because his credibility will be directly challenged before the jury, his acknowledged personal animosity only reinforces the propriety of his withdrawal. It likewise bears on the jury's assessment of his credibility and motives as a witness. Finally, Mr. Cartagena's decision not to oppose Mr. Blackburn's withdrawal should not be construed as an acknowledgement that Mr. Blackburn may thereby avoid this court's authority with respect to his own conduct. To the contrary, the court retains jurisdiction over Mr. Blackburn to adjudicate the pending motions for sanctions and contempt arising from his conduct in these proceedings. And they cite a case called Hong v. Mommy's Jamaican Market that held the court has jurisdiction to sanction counsel for his conduct before this court because it is a collateral issue that the court can consider even after an action is terminated. That the court can consider such a collateral issue even after the attorney has withdrawn his counsel. And then they also cite Logicom Inclusive, Inc. versus W.P. Stewart and Company that held as for defendant's contemplated claim against plaintiff's counsel for Rule 11 sanctions, his withdrawal from the case does not insulate him from such a claim for pre-withdrawal litigation conduct. This court will retain jurisdiction over a Rule 11 sanctions claim if defendants decide to assert it. Then we've got more case law. Dangerfield v. Merrill Lynch, Pierce, Fenner, and Smith. Holding that an attorney's withdrawal from a case does not prevent the imposition of Rule 11 sanctions for papers filed prior to the withdrawal. More cases. We got Gold v. Last Experience, Houston v. City of New York, holding that the court-sanctioned attorneys where withdrawing from the case did not absolve the attorney of his Rule 11 obligations. Then back to the letter. Indeed, Mr. Blackburn himself acknowledges that his participation in this litigation will continue notwithstanding his withdrawal as counsel for Mr. Dixon. Specifically, he represents that he will continue to litigate as a pro se defendant, and further states that he intends to file a motion for summary judgment on behalf of himself and T.A. Blackburn Law. Having expressly acknowledged that he will remain an active litigant in his individual capacity, Mr. Blackburn cannot plausibly contend that his withdrawal as counsel divests this court of jurisdiction to resolve the pending motions directed to his own conduct. His withdrawal affects only his representation of Mr. Dixon. It has no effect whatsoever on this court's continuing authority to adjudicate motions for sanctions and contempt against him personally. Accordingly, Mr. Cartagena respectfully requested the court grant Mr. Blackburn's motion to withdraw as counsel for Mr. Dixon, while making clear that such withdrawal neither affects nor delays the court's adjudication of pending or future motions for sanctions or contempt directed at Mr. Blackburn's personal conduct. Your Honor's consideration in this matter is greatly appreciated. Respectfully submitted, Joseph Tacopina. Big old signature there. So there we go, you guys. I saw this update. I'm going to do a video essay on a wrongful conviction case. You've heard me mention Andrew Fleischman's work earlier this week. It is a case where his arguments, his client succeeded on their claims for wrongful conviction compensation. This is over in Georgia. It is a wild, wild case, but I've been in the bushes doing that. But wanted to get this out here so you guys saw this update today for this Fat Joe case, never-ending docket update saga. So hope you guys are doing well. Leave a comment. Take care. Take care of yourselves. See you next time we get together. Bye, guys.